get this. A whole bunch of Republicans in Congress just tried to derail a major, would-be historical honor for a prominent black judge. And it's not the story you're thinking of. I know there's a lot of attention being paid to Ketanji Brown Jackson, rightfully so, and how, as I make this video, she is on the verge of becoming the first black female justice on the Supreme Court. But while her confirmation hearing was going on, Republicans turned their back on another black judge, all because he dared to follow the Constitution decades ago in a case involving school prayer. This story hasn't gotten a ton of attention because there's a lot of bigger things happening right now, but I'm going to tell you all about it because I think it says a lot about how Christian nationalism really is the guiding principle for the bulk of the Republican Party and how it leads them in all the wrong places. Okay, here's the backstory. And just bear with me here, I promise the payoff is worth it. This is Joseph Woodrow Hatchett. He died in 2020 at age 88, which led to a lot of people remembering and talking about his legacy. And what you learn is that his legal career was historical for so many reasons. He was the first black Supreme Court justice in the state of Florida. After getting appointed to that seat in 1975, he had to run to keep that seat the following year, and he won, becoming the first black person in Florida to win a statewide contested election in the 20th century. In 1979, he was nominated by President Jimmy Carter to become a federal judge, and he soon became the first black federal appeals court judge in the Deep South. He held that position until 1999. At a time when he was the chief judge to retire and join a private practice. I know that's a lot of firsts, but here's why that matters. Because of Jim Crow-era laws that were in place in 1959, Hatchett had to take the Florida bar exam at a hotel where black people were not even permitted to stay in at the time. Hatchett passed the bar exam at a place that did not want him there, and he went on to become one of the most powerful, prominent, decorated judges in Florida history. He's in the National Bar Association Hall of Fame. So, when he died in 2020, people wanted to honor his legacy. That's why, last October, Congressman Al Lawson Jr., a Florida Democrat, filed a bill that would designate the federal building and United States courthouse located at 111 North Adams Street in Tallahassee, Florida, as the Joseph Woodrow Hatchett United States Courthouse and Federal Building. That is a very cool, very well-deserved honor for a guy who, for a Florida man, was pretty damn amazing. This was not a controversial proposal at all. Every single Florida House member, Democrat and Republican, signed on as co-sponsors of this bill, because of course this is something everyone wants credit for. Naming a courthouse after Judge Hatchett should have been a mere formality. It's about as controversial as a bill saying puppies are cute. Even Republican Senators Marco Rubio and Rick Scott, who are wrong about damn near everything, supported this proposal and got their version of the bill through the Senate through unanimous consent in December. Literally no one was fighting this. All the House needed to do was get 2/3 of the chamber to approve the proposal, and it would have been a done deal. They were going to fast-track this thing so that Joe Biden could sign it ASAP without the bill having to go through all the usual procedural hurdles. Because virtually no one opposed it. Let me say this again because it's important. The Senate, which is fundamentally broken, was all for this. Not a single Republican said no. We can assume all the Democrats in the House were all on board with this too. So even if a couple of crazy Republicans said no for whatever reason, this should have easily gotten over 67% of the House saying yes. This should have easily passed. This should have been a given. You know where I'm going with this, right? The bill did not get 67% of the votes it needed in the House. This bill was not fast-tracked to Joe Biden's desk. That's because only about 60% of House members voted for it. They couldn't get the 67% they needed to overcome the hurdles. So what happened? The short answer is that a whole bunch of Republicans suddenly decided they could not support the plan to rename the courthouse. Most of them only chimed in moments before the vote ended. And before I go on, let me be clear about this. The bill is not dead, but it will have to go through a longer approval process now. This thing should have been like TSA pre-checked, but now it has to go through the longer security line that applies to everybody else. It's just annoying for no good reason at all. So what happened to change those Republicans' minds? Well, a Georgia congressman named Andrew Clyde happened. He began circulating a ruling written by Judge Hatchett in 1999 that involves school prayer. And once those other Republicans saw it, they turned their backs on honoring him. Must have been one hell of a horrible decision, right? Of course not. Here's what that case is all about. For many years, the Duval County Public School District in Florida allowed chaplains, literal chaplains, to lead prayers during high school graduation ceremonies. They had formal Christian prayers at graduation. And maybe you're thinking, wait a minute, I thought that was illegal. Well, it wasn't declared illegal until 1992, when the Supreme Court said it was unconstitutional in a case called Lee versus Wiseman. The court specifically said those types of school-sponsored, administrator-approved prayers were illegal. And obviously that ruling now applied to Duval County. School officials, however, did not want to get rid of their prayers. So instead of just removing them from the ceremony, they tried to carve out a loophole. In 1993, the year after that Supreme Court decision, the district announced that graduating seniors could vote for someone in their class to deliver opening or closing remarks at their ceremonies, and administrators would not preview that speech in advance. And, if those students happened to deliver a Christian prayer with their time, wink wink, well, it's not like the district knew anything about that, so technically no one could say it was school-sponsored prayer. They seriously thought that would be a creative workaround that would allow them to say they're following the Supreme Court's ruling while still making sure Christianity was part of the public school graduation ceremonies. And guess what? That is exactly how it played out for them. In 1993, of the 17 high schools in the district, 10 of them had a formal prayer at graduation. And just to state the obvious, everyone is always allowed to pray at graduation on their own. Parents can do it. Administrators can do it. Students can do it. If you genuinely think you can talk to God, then a silent, private prayer in your mind should be fine. I'm sure your God can hear you. But that's never what these Christians want. They want everyone to be subject to their religion. They wanted a Christian prayer delivered on stage through the microphone because they wanted to make sure every student heard about Jesus, including all the non-Christian ones. I mean, especially the non-Christian ones. This was about Christian supremacy, plain and simple. So, the bottom line here was that even though the Supreme Court said school-sponsored prayers at public school graduations were illegal, this district was continuing school-sponsored prayers at public school graduations. But some students weren't about to let that happen. That year, a bunch of graduating seniors filed a lawsuit against the district saying what they were doing was wrong. And those kids were right. The district was wrong. But because of legal technicalities, like the fact that those students graduated and therefore did not have legal standing anymore, that lawsuit didn't go anywhere. It was tossed out. It wasn't until 1998 that another challenge finally worked. Students argued that the district's policy was still unconstitutional, and the case eventually reached the 11th Circuit Court of Appeals. That's the level right below the Supreme Court. And guess who was the chief judge of that court? Just a guy named Joseph Woodrow Hatchett, who happened to be assigned to this particular case. It was a 2-1 decision. Hatchett said the district's workaround was unconstitutional because it violated Lee versus Wiseman. He was right about that. Thankfully, one of his colleagues agreed with him, and that was enough to put a stop to this nonsense. Here's what Hatchett wrote in his decision, referencing that Supreme Court case. Our review of Lee and cases from other circuits leads us to the conclusion that the delegation of the decision regarding a prayer or message to the vote of graduating students does not erase the imprint of the state from graduation prayer. Further, the Duval County school system developed this policy as an attempt to circumvent Lee and continue the practice of prayer and to permit sectarian and proselytizing prayer at graduation ceremonies. Let me translate that for you. We know what you're doing. You're trying to skirt the law by allowing seniors to elect someone to deliver a prayer instead of assigning someone to do it yourself. But what you're doing is still school-sponsored prayer, and everyone knows it, and any reasonable person watching these ceremonies would think the district is promoting prayer, and we, the judges, are not going to let that happen. Stop trying to cheat the system. Now, if you're the sort of person who does not like activist judges, wants judges who respect legal precedent, and believes religion is best left to families instead of school officials, then you should support that decision. It's the right call. Republicans specifically should have loved that opinion. But if you're a Republican who worries that expressing support for a judge who once ruled against Christian prayers in public schools might make you vulnerable to an increasingly extremist and very religious voter base, then who cares about judicial philosophy, am I right? 147 Republicans voted against fast-tracking the renaming of the courthouse to honor Judge Hatchett because of that ruling. 147. And 10 of those dissenters were from Florida, which means all 10 of those dissenters had previously co-sponsored the bill to rename the courthouse. They voted against a bill they initially wanted credit for. And not only did those 10 Republicans co-sponsor the bill, one of them, Byron Donalds, is one of only 2 black Republicans in the House. One of the other flip-floppers was Matt Gaetz, which at least makes some sense because why would he ever do the right thing? Republicans are such hypocrites that a whole bunch of them voted against their own bill because a judge respected church-state separation more than 2 decades ago, and that's somehow a bad thing now. Because these Christians want to live in a Christian theocracy. They're genuinely afraid their voters will be mad at them for honoring a historic black judge who once said the right thing about school prayer. You want to know what's especially disgusting about all of this? The guy who spearheaded the smear campaign was Representative Andrew Clyde, who was one of only 3 members of Congress to oppose the recent Emmett Till Anti-Lynching Act. He was against anti-lynching legislation. He was against treating lynching as a hate crime. Clyde also spread lies about Ketanji Brown Jackson, and he also called the January 6th insurrection attempt a normal tourist visit, even though there are literally pictures of Clyde hiding from and shielding himself against the attackers. This guy is a moral monster who no one in their right mind should be listening to. And yet, he derailed a bill that would have honored a black judge who accomplished far more in his life than Andrew Clyde ever will. And enough Republicans in the House fell for it. It's just an entire party full of the most spineless, awful people in the country. Do you know how horrible a politician you have to be to make Marco Rubio and Rick Scott look like voices of reason? And here's the thing. This bill will almost certainly pass. That courthouse will be renamed in honor of Judge Hatchett. But it won't happen immediately because those Republicans blocked the quicker option. Whenever it does pass, though, just remember that most Republicans were too scared to vote yes on a gimme bill because they feared a correct decision by a historic judge would hurt their re-election chances.